Welcome to Crash Course, a podcast about business, political, and social disruption, and what we can learn from it. I'm Tim O'Brien. Today's Crash Course, Trump versus the law. Manhattan District Attorney Alvin Bragg recently charged former President Donald Trump with crimes related to multiple acts of fraudulent bookkeeping. And because it involves Trump, of course, the charges pertain to hush money payments Trump paid to a porn star to cover up a sexual tryst. Bragg's case sparked vigorous debates about when presidents are and aren't fair game for law enforcement officials. I happen to believe that no one, including the president, is above the law, but there are good and diverse perspectives on all sides of this issue. To help me examine Trump's collision with the rule of law and the tar pit of legal cases and investigations engulfing the former president in New York, Georgia, Washington, and elsewhere, I invited Noah Feldman to our podcast. Noah is a Harvard law professor, a Bloomberg Opinion columnist, and a wildly graceful writer and thinker. Welcome, Noah.
Good morning.
So you recently wrote a column for Bloomberg Opinion taking the Manhattan District Attorney Alvin Bragg to task for bringing a case against Donald Trump, a fraud case against him, not so much in terms of the bona fides of the case, but the timing of the case. And I wanted you to talk to me a little bit about that.
Donald Trump, as both of us have good reason to know, and as I suspect listeners know too, fundamentally challenged the legitimacy of our democracy. And there are potential criminal charges against him for that could come either from the Department of Justice through the special prosecutor there, focusing on the January 6 events and time around that, or from Georgia prosecutors who have a tape that many of us have heard that shows Trump trying to break the outcome of the election in Georgia and asking the governor and the Secretary of State to find him more votes. Now, those are charges, criminal charges, that go to the core of what Trump did that was very bad. In contrast, this charge, essentially for creating a false business record by recording hush money payments to Stormy Daniels as legal expenses rather than as hush money payments, is about something that Trump did in the run-up to his election that we've known about for a long time, that if it occurred as is alleged, is probably criminal. We can come back to the probably, but which does not go to the core of the bad things that he's done. And that creates a situation where Trump can say his familiar line, look at the political witch hunt against me. And that makes it harder for the other prosecutors. So it's because I so much want to see Trump charged, especially by the Department of Justice, for interfering with democracy, that I'm concerned about the timing of this prosecution.
So, the thing I wonder about in this debate is there is the legal theory of the law and the crystalline palace that the law exists in. And then there's the real world in which prosecutors have to apply the law. And Alvin Bragg is his own operator. He is looking at New York state laws. He's looking at the things in front of him. He exists in an office that was already deeply divided about a previous case they thought they might bring against Trump. And Bragg decided not to do it, causing some people from his office to resign. Is he meant to coordinate his actions with prosecutors in other jurisdictions? Or are you simply saying, wake up, look at the world around you, and think about your actions in that context?
All of the above. So when there's somebody who's going to be prosecuted for federal and state crimes, it's common practice for federal and state prosecutors to talk to each other. There's nothing unethical about it. In fact, it's completely normal. And they strategize and work together when they're trying to put bad guys in jail. And so it would have been perfectly appropriate to have timing conversations here. However, you might say, given the sensitivity of prosecution of a president and the worries about keeping a secret, maybe they didn't want to coordinate. And if that's the case, if you're Alvin Bragg, sit back and let the more serious cases against Trump proceed, and then bring your charges because you have discretion to bring them whenever you want, provided you're inside of the statute of limitations. So either way would have been fine. And I will just add, Tim, you alluded to the fact that prosecutors had other charges they wanted to bring against Trump. Those were stronger charges on legal grounds. Those were charges against Trump for falsifying his assets in loan applications, which were what you would call straightforward felonies.
And possibly decades of misleading banks to get loans from them under false pretenses.
Exactly. And that is an easily provable felony on the numbers in front of a jury. In contrast, this charge, A, will be hard to get a jury of 12 to agree to because Trump can defend himself by saying, sure, I falsified the record, but I did it because I was worried about personal embarrassment, and all it takes is one juror to believe that to get a mistrial. But also it's vulnerable on appeal in a way that the other charge wouldn't have been.
This is interesting that you are more of an advocate for that prior case than the current one that the Manhattan DA was looking at, because I was skeptical of the first case as well, simply because everything I heard coming out of that office was that they were basing Trump's ability to hoodwink sophisticated lenders like banks, was that he was using these ginned up statements of financial condition as the groundwork for getting loans. And Trump produced those things about as often as you and I produce birthday cards. And they weren't audited. I don't think any bank really relied on them. And so I think there would have been an evidentiary problem going to court claiming that sophisticated lenders were actually duped by a guy giving them unvetted documents. And I do think that that was ultimately one of the fractious issues that split the office apart. I had thought they were wise not to rush that one to court. What hangs me up on the current issue is, again, the idea of being an independent operator as a prosecutor and coordinating with other jurisdictions. And I know you already addressed this, but famous examples are in a local jurisdiction where you have a criminal probe and a civil probe. Say the SEC is looking at civil charges and the U.S. Attorney's Office is looking at criminal charges. The SEC will step aside because the criminal charges have greater weight and therefore are seen as being more important. I don't understand at all how this works when Alvin Bragg in New York has to think about Fonnie Willis in Georgia, who has to think about Letitia James in upstate New York, who has to think about a special counsel in Washington working for an attorney general who actually hasn't filed any charges yet. Like, how do you navigate that star system?
I'm tempted to say this is why the good Lord invented the conference call. It's a little flippant, but in any case where you had multiple jurisdictions overlapping, the ordinary thing to do, and again, this is not an ordinary case, but an ordinary thing to do would be to have everybody at the table, literally or metaphorically, and weigh out different priorities. And is it a bit of a game where nobody works for the same boss? Yes, it is a bit of a game. There's a little bit of a negotiating component where everybody could threaten to go earlier or offer to go later, and that does happen. But ordinarily, it's worked out collaboratively because all of the prosecutors typically have the overlapping interest of seeing the person convicted of the charges that they want to bring, and they have reason to order the process in order to make that happen. So that could have happened here. And again, the only argument against that would be confidentiality concerns. Now, the hardest part here is that because the DOJ has a whole process for deciding to bring charges, you probably couldn't have that conversation with Merrick Garland, the Attorney General, because the special prosecutor, Jack Smith, is right now in charge of the case. But the ultimate charging decision would still be made by Garland. So that might make it a little bit trickier.
Another tricky element is that Merrick Garland appears to have the metabolism of molasses. And I say that as a impatient journalist, not a objective academic such as yourself. And I know that Garland is trying in a very admirable way to pin down the evidence, pin down the fact pattern, and if he's going to go with something, make sure it's airtight. But if you're Bragg sitting in New York, how do you have any faith that actually that federal prosecution is going to occur? And why do you put your measly little local prosecution aside if Hamlet is sitting in the Justice Department?
In the first instance, I'm glad you acknowledged what I think is true, which is that the Attorney General has a really hard job here. His whole goal, the reason he left the Court of Appeals to become Attorney General, was to depoliticize the FBI and the Department of Justice when it comes to prosecuting decisions. And here you have what inherently would be the most political prosecuting decision in U.S. history, a decision by the current administration to prosecute the guy they beat running for office who's now running against them. So you really want to get all your ducks in a row before you do that, and you want to be thoughtful and wise around that. From Alvin Bragg's perspective, you're right that he can't say with any confidence that those charges will be brought because they won't tell him with any certainty whether those charges are going to be brought, even if they already know, which it's entirely possible that they don't. But he wouldn't have had to put aside his prosecution indefinitely. He would just have had to sit on it until we got some sense of what the DOJ was going to do, which we certainly will have before the presidential election season really heats up. Because it's certainly the case that the Department of Justice is not going to bring criminal charges against Donald Trump in the middle of a hot primary season, because that would simply look too political. So before that time in the calendar comes, Bragg could have known whether to go forward or not, and he could have done it at that point.
And of course, there's the larger, I think, reality of if Bragg secures a criminal conviction here, which is still an if, convincing a jury might be hard, and making these charges stick, therefore, might be hard. The idea that this is going to land Donald Trump in an orange jumpsuit, I still think is a stretch. And so for people wanting Trump to be held accountable for his most heinous violations of the laws, this doesn't meet that standard. And for people who are invested in the idea that somehow he'll be brought to rough justice, it may not end up there either, right?
It absolutely may not. And that leads to a number of scenarios that are actually pretty worrisome. One is a criminal trial taking place sometime between, say, January and May of 2024, while the primary season is going strong. And although Donald Trump might ask the prosecutors to delay even past that time on the theory that it messes with our democracy, it's unlikely that the prosecutors would delay it indefinitely for him. And so then you would have this bizarre scenario of a county prosecutor bringing criminal charges against a candidate for the presidency, and possibly a successful candidate for the presidency.
A nominee.
Exactly. So that's the next question. What if he's the nominee and now he's undergoing criminal charges? What if he's been elected president? What if he's president-elect, heaven forbid, and is undergoing criminal charges? What if he's already president and the criminal charges are going forward? And in all of these scenarios, Trump would go first to the New York courts and then the federal courts, and he would say to them, hey, stop this shenanigan right now. Put a pause on this until after I've served my term as president. And that also puts the Supreme Court of the United States in a very difficult position, because if they say to Trump, no one is above the law, then he could actually be fighting a criminal charge or imprisoned, however briefly, while serving as president of the United States. And so that's absurd. I mean, the president of the United States can't run our national security apparatus out of Rikers. So that's not a plausible option. But on the other hand, if the court says, sure, we'll delay this, then you can imagine a president whose entire term in office is under the shadow of a potential conviction, or who has actually been convicted of a crime. And so talk about a violation of the deep principles of the rule of law there. So there's no good outcome in that scenario. And that's another thing that I'm a bit concerned about here. And just to say, of course, that could all happen if the DOJ charges were brought, or it could happen under the Georgia charges. But I think those are a little bit different, because in those cases, those would be literally charges for trying to break the democratic election system. And those might be the only set of conditions where it's reasonable to charge someone like Donald Trump, who has been president and is now running for president.
So we're going to explore those other cases in a bit, in a little more depth. But I want to roll you back on the scenario of him running for president from jail. And he complains to the courts that he's being unfairly impaired. Well, the court says, well, Eugene Debs ran for president from jail in the 1920s. And Lyndon LaRouche got convicted 5 times, I think, on tax fraud. And that didn't stop him from running for president. So there's precedent for people doing this. Stop whining, put on your big boy boots, and get out there and campaign, sir.
Of course, the courts could reach that conclusion. One difference between Trump and the Debs case is that Debs was in federal prison, by the way, under a law that today we would consider blatantly unconstitutional. That basically he was literally imprisoned for giving a speech where he said, yes, I support the people who are refusing to serve in the First World War because it's immoral. But in any event,
we're imprisoning you for exercising your First Amendment rights.
Yeah, literally. It was at a time when our First Amendment rights were very, very far from defined. But in any event, that was a federal charge. And at least you can say there that the U.S. government had to decide to bring the charge against him. There are some high 4,000s numbers of district attorneys in the United States. And any of them can bring a charge, and any local jury can convict. And Trump would have a credible argument to be made that the idea that not only one state, but one county in one state could impair a presidential candidate to that degree is a little bit worrisome. And, you know, for those who hear this and think, as I would instinctively think, but Trump is special, the issue isn't whether Trump is special. The issue is whether there is somewhere in the United States an irresponsible prosecutor in a backwater place who will say, you know what, Joe Biden is looking a little like he's riding a little high. I'm indicting him on some charge that has enough weight to it to get to a jury. And then the appeals courts say, well, we're not going to throw this case out until you try it to the jury. And so there is a real danger that giving that much power to district attorneys all over the country could undermine our political system more broadly. And that's something I think we genuinely have to be concerned about in a world where political polarization goes down to every level of government, and it certainly goes down to local district attorneys, and where the idea that crime or criminal charges are a tool in the political process is now in the air.
Well, and this is one of the conundrums of Trump as president, is that we have some fairly sophisticated and honorable reasons why we give the presidency certain protections, and we give the occupant of the Oval Office certain protections, both from the law and from conflict of interest policies. Unfortunately, probably the framers and everyone who wrote a law up until, say, 2016 never envisioned someone like Donald Trump inhabiting the office and using those protections in such a damaging and self-serving way, ultimately in a way that is allowing him, I think, to undermine some of the foundations of the Constitution or to attempt to do so. So where does the line stop, Noah, between observing the necessary installations of the office and making sure that things don't go haywire when Godzilla ends up in the White House?
You know, I basically agree 100% with what you just said, Tim, about how Trump has at every stage just blown up our norms. I mean, the reason we don't worry most of the time about these local district attorneys is they're not all insane, and most presidential candidates aren't as susceptible to this kind of thing. Where I would draw the line, though, is if the charges are specific to a challenge to our democratic system. Because then the person bringing the charges has to balance between two competing democratic interests, the democratic interest with a small d in allowing the primaries to run, and the small d democratic interest in making sure that we don't elect someone who tries to break our constitutional system and who you're charging with doing exactly that to a jury. I don't think it's an arbitrary line to draw. I think it's a sensible line to draw to say those charges I would bring, even if that means bringing criminal charges against a former president or a presidential candidate. But I would be very nervous about bringing charges on a claim like the one that was brought here, especially given its potential legal risks associated with it.
So in other words, it's fair game, regardless of the political consequences, to hold a president or an ex-president accountable under the law if the issues you're holding him or her accountable for pertains to the exercise of the powers of his or her office.
Exactly.
But if it's adjacent to that or even ancillary, then hands off for the time being.
That's exactly where I would draw the line. And if you think about it, January 6th is a unique, it's never happened before, attempt to break the transition of power. I'm not talking about just the day itself, but of Trump's conduct around it. And if you don't charge that, then you're basically saying to someone who's a potential, would-be dictator, go for it. The criminal justice system won't touch you. And that can't be right either.
This feels like a good stopping point. So let's take a break. And when we return, we'll zoom in on Letitia James's investigation in New York. So we're back with Noah Feldman, the Harvard Law School legal guru who's guiding me through a deeper understanding of the court cases arrayed against former President Donald Trump. Let's go from New York City to upstate New York, where the Attorney General of the state of New York, Letitia James, is prosecuting Trump for financial fraud as well. It's a civil case. I think it's probably a much more elaborated case than Alvin Bragg's. She began it before Bragg did. She is actually traversing some of the territory that Bragg's office initially investigated, whether or not Donald Trump lied to the tax authorities about the value of his properties when he wanted to lower his tax bills, and then inflated the value of his properties when he wanted loans from banks, and told whatever story he needed to the relevant authorities. And she's looking at a pattern of fraud across a number of deals that he's done where that issue came into play. Basically cooking his books to get a loan when he needed it or to lower his tax bill when he needed it. None of that goes to his powers as president. I think she was very injudicious in the run-up to filing charges. I think when she ran for Attorney General, she said that she wanted to hold Donald Trump accountable for his crimes. So she had extrajudiciary comments about her intentions prior to filing charges. So in that context, and given what you just laid out as the proper venue for going after a president legally, would you say the James case also should be put aside?
Like you, I have my reservations about the apparently political way in which it was presented. But, and it's a substantial but, it's a civil case. And we know from the Paula Jones precedent that, at least according to the U.S. Supreme Court, as the law currently stands, even a sitting president can be prosecuted civilly, can be brought to be a defendant in a civil trial on a matter arising from conduct before he became president. Now, it didn't go very well in the Paula Jones case because it eventually led to, by various complex means, an impeachment and a presidential lie under oath. So a lot of people think the Supreme Court got that wrong and they should have delayed that case. But the president is still on the books, and it stands very strongly for the idea that even the president of the United States is subject to civil process and can be sued and can't even get a delay for it. So that reality gives some support to the idea that you can go forward with a civil case, because bottom line, there's something really different about the idea you'd have to pay money and the idea that you could go to prison. And that's especially relevant when the person is running for president or would be president because of the obvious fact that you can't do the presidency from within a prison cell.
So I've learned something else right now with you here. So in the New York State civil case that Attorney General Letitia James is overseeing, a civil penalty would maybe result in a massive fine for Trump and his company and his children. It might even put them out of business in the state of New York, but it wouldn't preclude him from running for office. Therefore, fair game.
Yeah, I think so. It doesn't have the same degree of interference, both at a practical level and also at the psychological level of a defendant for whom, paying money wouldn't be good, but for whom going to prison is a fundamental loss of your liberty. So I do think that it is fair game. That said, could it have been presented in a different way? Yes. And could an attorney general exercise discretion so as not to set a precedent of prosecutors somewhere else going after the Bidens when they're running for office? Yes, that would have been a reasonable exercise of prosecutorial discretion. But I don't think it's off the table altogether in a civil case.
And by the way, Trump almost invites this sometimes, given how grotesque his behavior towards the judiciary is. He's invited anti-Semitic tropes in talking about Bragg's investigation. He's lied about Bragg's campaign being funded by George Soros. He's called both the black prosecutors in New York State racists. He's sort of invoked both racism and anti-Semitism at every turn in this. And most recently, after he was arraigned, he and his children launched veiled sort of threats against the judge hearing the case in New York, as well as his wife and daughter. This is another moment in which Trump is challenging civic norms. And one, it challenges the rest of us, including law enforcement officials, to respond in a civil fashion, even if he's not doing so himself. But it does reveal, I think, another kind of strain or stress that's being placed on the rule of law and law enforcement is this extrajudicial attacks Trump is constantly making on the institutions and the people who inhabit them.
I mean, I agree with everything you just said. It's deeply disturbing and distressing to see his attempts to subvert the judiciary. And it puts the judges in a very difficult situation. On the one hand, they must be tempted to say, well, we're going to double down in being tough on you. On the other hand, they want to bend over backwards to appear fair. And there was some hint of this, actually, when Trump and his lawyers were in court at the arraignment, insofar as the trial judge urged, he didn't precisely order, but urged Trump to cool it on social media with respect to things like an image that Trump posted of himself with a baseball bat, menacing Alvin Bragg. And although the judge didn't say so, of course, the implication is, don't dox me, don't put me in the crosshairs, or there could be legal consequences for you. And, we know that Trump's MO always has been and always will be to push the envelope as far as he can push it. And you can see him taking action that under other circumstances would get a normal person charged with contempt in a judge's court by, for example, threatening the judge. So we'll see. I mean, his lawyers will be bending over backwards to tell him, whatever you do, don't do that. But
which he will routinely ignore.
Exactly.
He's Donald Trump.
We've seen that many, many times.
But his lawyers will also come up with great excuses for his behavior, like post-arraignment. His lawyer said Trump was only holding the baseball bat up because he really wanted to show that it was an American-made bat. So he's just pro-industry. So the way I'm thinking of it here is we're actually moving up a prosecutorial food chain here in terms of the gravity of the consequences for Trump and the issues that are being tested. So let's go out of New York State and go to Georgia, to Fulton County, where the Fulton County District Attorney Fani Willis has launched a criminal fraud probe into electoral fraud, investigating whether Trump tried to overturn the vote in Georgia after the 2020 election, a vote he lost to Joe Biden by over 11,000 votes. There is a smoking gun in that case. There's a recording of Trump calling the Secretary of State and encouraging him to go out and find Trump another 11,000 plus votes so he can win the election.
So, look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state.
She's already convened a grand jury. This looks like a perilous case for Trump, but I'd really love to know your thoughts about the merits of that particular action.
Well, to start with what we know and don't know, we know the grand jury wasn't just impaneled, but issued indictments. And we don't exactly know whether Trump was named. On the one hand, they haven't said so. They haven't said not. And when the foreperson of the grand jury made her brief circuit of the talk shows, she said things that were a little opaque, like, you won't be surprised by what's in there. And, that really depends on what she thinks of as being surprised by. But let's assume for the sake of argument that Trump is named in that indictment. If that's the case, then basically the Fulton County District Attorneys need to act relatively soon so that they minimize any appearance of politicization, because the timing here is an issue, right? They have their document in hand. So if they're going to indict, they should really do it in reasonably due course so that Trump can defend himself against the charges. But I think the good news is a trial would lead to a genuine public conversation about what Trump was doing on these phone calls as he tried, in my opinion, to bully elected officials to falsify election results. And a reminder of that would be timely as Trump is setting up to run for office again in Georgia and other places like that. And from a political perspective, it would be especially significant because if Trump is to be defeated by another Republican candidate in any of these primaries, it will have to be that that person gets some of the votes, or a lot of the votes, of what you might call conservative Republicans who think Donald Trump is a clown, and nevertheless would like to elect different conservative Republicans, because that's what most of the other candidates are going to be. And those folks are the people who might be most likely to be influenced by a reminder of what Trump did to Republican elected officials in Georgia. Those Republican elected officials resisted Trump and, for the most part, managed to get reelected nevertheless. So that's an important message in practical political terms and also in constitutional legal terms. I think this is the time to be reminded of that threat.
So according to what I'll call for the purposes of our podcast, the Feldman Standard, the Georgia prosecution is important and meets that hurdle of when you actually do take legal action against a current or former president, because it goes towards the fundamental exercises of the duties of their office and or observations of democratic and constitutional norms.
Exactly. What he's doing on those phone calls is trying to break democracy. And that's something we need to be reminded of and should be reminded of when the guy's running for office again.
So now we go to the one that I find the most interesting, still the most mysterious, and possibly the most consequential investigation. It is not a prosecution yet, and that's at the Department of Justice. The DOJ has had a long-standing, at this point, and sprawling examination and investigation and successful prosecution of participants in the January 6th insurrection, the January 6th, 2021 insurrection at the U.S. Capitol, looking into whether or not it was a orchestrated plot and what laws were broken. This has started to get closer and closer to Trump and some of his minions when it touches on things like insurrection and intent to disrupt an electoral process. In the course of that investigation, another investigation emerged when it was discovered that Trump had classified documents at Mar-a-Lago that had, at a minimum, hadn't been properly accounted for, may have involved outright misappropriation, may have involved obstruction of justice when it was discovered he still had these documents, and also could be consequential, violations of the Espionage Act and other laws governing how federal records should be properly handled. When that second investigation emerged, Merrick Garland appointed a special counsel to oversee both of them, Jack Smith, a veteran prosecutor. And that's sort of where we are right now. We have a well-regarded and capable special prosecutor under the aegis of a well-regarded and thoughtful attorney general, both of whom I think have longstanding reputations for upholding the rule of law and the processes that surround it, deciding whether or not they have enough evidence to charge a former president. And if they do, what are the consequences? So I have some other thoughts on that, but I'm more interested in yours. Tell me how you're thinking about the whole DOJ action right now.
Well, let's start with the second point you mentioned, the Trump withholding confidential secret documents when he left office. That, when we heard about it, seemed like great news from the standpoint of those who would like to see Trump brought to justice, insofar as it's a pretty objective thing to prove. Had the documents, asked for them, didn't give them back, and they've got, secret written all over them. What's unfortunately happened is that because of what seems almost certainly to have been carelessness on the part of Joe Biden, there are some number of confidential documents or secret documents that also remained in Biden's possession, and Biden and his lawyers were not completely forthcoming about the timing of discovering those, albeit it wasn't the same situation where they had been requested and they held them back, which might matter for purposes of a crime. They did hold off on when they announced the fact of that, and the timing looks like it may have been connected to the midterm elections. And
Biden gave the unconvincing argument that it was safely secured next to his Corvette in his garage.
Truly laughable. So what basically Joe Biden did in that situation is he rendered it almost impossible for the prosecutor to lead against a prosecution of Trump with the withholding of documents because of the critique that will be made that says, you are the Department of Justice, and you are ultimately answerable to the president, and you're charging someone else with a crime that arguably you committed, and you are notably not going to be charged with it. I think so that's one reason they can't really go forward. Another issue is that many administrations, we now realize, have this phenomenon. So many documents are classified that some things accidentally make it into files when they leave. Of course, an accident is not the same as on purpose. Had they chosen to prosecute Trump on this, they could have said, well, this is very different than the ordinary case of a mistake. But it is one of those things that is just sitting there waiting for presidents to use to charge their predecessors. And in that sense, it's also something to be worried about if it becomes genuinely routine. But the January 6th investigation is a whole different thing.
Wait, before we go to January 6th, I just want to stay on the classified documents issue for a second. There are other issues attendant to Trump that weren't present with Biden or with Mike Pence, it would appear, or any number of other federal officials who it now seems accidentally wound up with classified documents in their folders, which is it appears that Biden, once his lawyers notified him that he was in possession of these documents, made a good faith effort to locate any that might be outstanding and turn them over to federal officials. In Trump's case, there appears to have been what also might be a conspiracy to cover up the number of documents they have, to move their location, to doctor cameras that had recordings of the movement of those documents, all in the service of obstruction of justice. So if there's not an Espionage Act violation here, there still could be an obstruction of justice violation, right?
You're absolutely right. And again, if other charges are brought against Trump by the federal government, they would probably throw those in. The question is whether you could go with just those. So let's imagine a conscientious prosecutor decided that Trump's conduct around January 6th can't be proven to a jury beyond a reasonable doubt to be incitement, and that things he said behind closed doors don't amount to a conspiracy to block the election. I mean, just imagine this. It's not necessarily the conclusion that I would reach, but it's a conclusion that a prosecutor could reach, but then says, but we should still prosecute him on the documents. What I'm saying is, notwithstanding that you're right to say there would be obstruction charges there, it's still the case that the violations by Biden, even though they're not really comparable in a lot of ways, will have the political effect, I predict, of convincing the prosecutors, including the Attorney General, to say, I can't go forward with this because it will look too much like I'm going after the other side's candidate whom we beat for something that we also in some way did. What that is a prediction about how Merrick Garland's judgment is likely to go. And if you ask me, but would he be right in doing that? The honest truth is I think the answer is yes. I think that when you're going to, for the first time ever, prosecute a former president, and when you're the person doing it is the president running for office against him, you really need to bend over backwards to be clear that it doesn't look in any way, shape, or form like it's a politically motivated prosecution.
And he'd be making the same decisions or decisions in the same neighborhood that you don't think Bragg properly made or strategically made, that Garland would think through the strategic implications of which prosecutions he's going to bring.
Yes, there's no question about that.
So I interrupted you. Let's go on to the big Megillah, the January 6th insurrection.
Yeah, so the January 6th insurrection is a set of events where many people have now been charged criminally. But I think almost without exception, they were people who themselves entered the Capitol on January 6th. There may be some people who conspired to facilitate that and didn't actually cross into the Capitol who've been prosecuted, but I'm not aware of any to date. And that's good and important. There need to be prosecutions there. But there still remains the question of the person who pushed people to do this, which was Donald Trump. And so the primary issue for that prosecution is, can you charge Trump criminally with incitement there? We should talk about that because it's not a simple question. And then there's the secondary question, but I think its own way equally important, of whether things that Trump said or did behind the scenes, so not when he was addressing the crowd, but when he was addressing his associates about what should be encouraged, when he was talking to people from the Department of Justice about whether he should appoint an attorney general who would help him in some way subvert the election, when he was talking to Department of Defense officials about whether he could get the military to take some action on his behalf. Those pieces of conduct, I think, could arguably, by a prosecutor, be tied together into a broader conspiracy to defraud the American public about the election and subvert the election results. And that seems to me to be a very, very serious potential criminal charge, really one of the highest order of importance.
And the 14th Amendment comes into play here. The 14th Amendment references insurrection and the crime of insurrection as precluding anyone from holding a state or federal office. It was written into the amendment after the Civil War to prevent Confederate officials from holding high office in the wake of the Civil War. That, at the end of the day, could be the single most important roadblock to Donald Trump going back into the White House if he gets convicted on an insurrection charge.
That's true. If the conviction were a conviction for insurrection, then under the plain meaning of the 14th Amendment, Trump would not be able to serve as president.
What is your sense of the timing on this? Garland has been, I think, thoughtful, tentative, and in my journalistic mind, slow, but that's unfair. I'm just being impatient. Is he just going to let the fact pattern play out and prosecute and file charges if and when he thinks the time is right? Or is he going to wait until after 2024 by purpose?
It seems to me that if Garland is going to bring charges before the election season, it has to really be before the primary season heats up. I think there is it's not a legal deadline, but an implicit policy deadline that would say the sitting president should not bring charges, if at all possible to avoid, against a potentially leading candidate running against him once the election season is really underway. So it seems to me that he has some months left where that charging decision can be made. But if he didn't bring charges, let's say a month or two before the first Republican primaries, then it's pretty clear that he won't bring those charges before the elections are over. And I think that is a correct view. I mean, he ought to do that. He ought to be as careful as he possibly can be around that, lest people say, well, why didn't you bring these charges earlier if they could have been defended against and dealt with since the facts were already ascertained? Again, remember, Garland first has to wait for Jack Smith, the special prosecutor, to tell him what to do. And given how important this case is, everything is going to be carefully recorded, and Garland is not going to be poking around. He will sit and wait for Smith because that's what the procedure is supposed to look like. For his part, Smith himself will also bend over backwards to make sure that his decision doesn't look like it's ultimately politically motivated. So that's the interface of those two folks.
So let's suppose, like good law-abiding citizens and prosecutors, they do wait for the clock to run a little longer so they don't appear to be intruding with the 2024 election. Then the 2024 election happens. Trump wins, and he replaces Merrick Garland as Attorney General.
If Trump is elected president of the United States, not only will he replace the Attorney General, even if charges were already brought, let's say they brought the charges during the lame duck, he could just dismiss the charges against himself. Because once he's sworn into office, he's prosecutor in chief. The case is the United States against Donald J. Trump. Well, when Donald J. Trump speaks for the United States, he will withdraw the charge. Now, we don't have the time for this scenario to arise, but if Trump were convicted of a federal crime and then was elected president, and swore the oath of office, and there's nothing in the Constitution saying he could not, to be clear, unless the charge was for insurrection, then Trump, I am sure, would assert his right to pardon himself. And there we'd have an unprecedented issue. My view, I've been saying this for the last 5-6 years, is that there's no way that the pardon power imagined in the Constitution could be used to self-pardon. It flatly contradicts the very idea of pardon, which is something you do for somebody else, and it flatly contradicts the idea.
That won't stop Donald Trump, Noah.
Well, exactly. And so then it'll go to the Supreme Court. So that issue would then go to the Supreme Court to determine whether his pardon was legit.
Well, you've just given me a perfect segue to my last big question for you, which is around the Supreme Court. But I want to take another quick break. And when we come back, we'll examine the role the 9 Supreme Court justices are going to play in all of this. We're back again with Noah Feldman, a legal expert and columnist who is sorting out the various meanings of the prosecutions and investigations arrayed against former President Donald Trump. You've written very eloquently about the evolution of the court over the last decade or so. I recommend everything you write about the court to everyone. You know the court in intimate ways. I think you clerked alongside Amy Coney Barrett in your younger life. You have great, I think, admiration for her mind and her legal record or her legal principles. But you've also written more recently, I think, about some of your disillusionment with how the court has evolved and some of the issues attendant to that. Do you think at the end of the day, the Supreme Court will be a good faith arbiter of the legal issues that might come in front of it in this era?
You know, I would sharply differentiate 2 aspects of the way the court has been doing things. One is what I would call their partisanship. They have not been, on the big scale of things, an extremely partisan court. And my main, case in chief is that Donald Trump in 2020 tried to get the Supreme Court to throw the election to him and brought many cases to the lower courts and to the Supreme Court. And the court had no time for that and no energy for that and no interest in that. And that includes the 3 justices whom he appointed. And lest we forget, there were lots of people really worried that Trump, having appointed 3 justices with this conservative majority, would be able to use the court to break the democracy. And the court wasn't buying that. So that's the good news. It means that I think the court would probably not be very personally inclined towards Trump. And I think that includes the justices whom he appointed. I don't think they have a sense of personal loyalty to him. So in that sense, I would predict they would not be partisan in the sense of giving the presidency to Donald Trump when he was not elected or otherwise letting him off. That said, the court is profoundly ideological, and its ideology has a political bent to it because it happens to be an ideology that maps onto the ideologies of the political parties. And so in that sense, if there were a case, for example, about whether Trump could continue to be criminally prosecuted in New York while serving as president, I think the kind of common sense instinct of the conservative justices would be, this would be thwarting the will of the American people. If the American people elected him, they would be thwarted if it were the case that he couldn't actually govern. And I have to say, I think probably if it were a Democratic president and the shoe were on the other foot, that same common sense instinct would sit with the liberal justices. And it would be the conservative justices saying rule of law, no one's above the law. So that is an example of something where you can't really separate politics and ideology from each other. And in that situation, yeah, I'm very confident that the Republican appointed justices who veer conservative would be pretty sympathetic to the claim that the newly elected president could still serve. I don't think that in their heart of hearts, most of the conservative justices want Trump to be reelected. I think he's an embarrassment, especially to the ones whom he appointed. But that's just a psychological assessment of their inner motives, not based on any actual evidence, rather than something I can sink my teeth into. What I can sink my teeth into is their jurisprudence, which, broadly speaking, is and remains extremely conservative. And as you mentioned, I've been really disappointed by the way that the pseudo-originalist arguments that the court has been making, not very principled conservative originalism, but very outcome-oriented decision-making.
So why wouldn't this court then say that Fani Willis has no business in Georgia standing in the way of the will of the American people?
Well, if the charges were still pending at a time when Trump was elected, I think that is what that court would say.
Mm-hmm.
If it's in the midst of a presidential campaign, I think it becomes a judgment call for them. Another reason why Fani Willis should decide to bring those charges again before the campaign heats up and really we enter the primary season. But for a charge brought any earlier than that, if Trump were to go to the federal courts and say, look, I'm running for president and I've said so, and therefore you can't charge me, I think the justices would realize that that would give an incentive for every person about to be charged with an offense in the United States to say, hey, I'm running for president, so you can't charge me. And so the court would not be inclined, I don't think, to announce some bright line rule that said the minute you file your paperwork to run for office, you can't be charged criminally, because that would set a very bad precedent. So, I think the court would be sympathetic once the election season is really up and running.
So Noah, in this collision between Trump and the law, and this era that we're in which Trump is challenging civic norms and legal institutions, what have you learned that you didn't know before all of this landed upon us? What are some of the ahas that are front of mind for you?
The biggest aha for me is that a value that we all usually like, namely prosecutors should do things slowly and methodically, is actually a disaster when it comes to someone like Donald Trump, a politician who has lost an election and is planning to run again. I wish that you and I were having this entire set of conversations 18 months ago, in the early days of the Biden administration, when whatever Trump might say about running for office, it was a long way off, before midterms, a whole different world. And that is a possible scenario to imagine. Notwithstanding what you were saying about the charges that the other prosecutors in the New York DA's office wanted to bring, and I'm happy to talk about that sometime in the future, basically old history at this point, those were charges that were ready at least a year ago, for what it's worth. And ditto for the Georgia case. The facts were gathered. It took a little bit longer, perhaps, in the case of the federal prosecution. But the danger that our political season keeps expanding in time, and that therefore it gets harder and harder to bring charges against someone like Donald Trump, is a real one. And so my takeaway is the thing that I really don't think I fully understood before we entered this season. I think I did understand that there was going to be a trade-off between protecting our political process and our democracy, seeming to be truly objective, and being truly objective meaningfully, and prosecuting Trump. I understood there was a trade-off. I didn't fully understand the time dimension. And as I see it, it fills me with regret that these processes didn't go by a lot more efficiently than they seem to have done.
Things move slowly, but this podcast moved quickly. We've run out of time, Noah, and I'm going to have to say goodbye. But I want to have you back soon, please.
I would love that. Great to talk to you, Tim.
If you're interested in following Noah Feldman more closely, and I recommend that you do, you can find him on Twitter at Noah R. Feldman, or find his columns on Bloomberg Opinion. Here at Crash Course, we believe that collisions can be messy, impressive, challenging, surprising, and always instructive. In today's Crash Course, I learned the Feldman rule. The idea that if you're going to go against a president in the court of law, you better go for the president's crown, and if necessary, avoid his wallet, especially if the president is someone as unacceptable and concerning as Donald Trump. What did you learn? We'd love to hear from you. You can tweet at the Bloomberg Opinion handle, @opinion, or me, @Tim O'Brien, using the hashtag Bloomberg Crash Course. You can also subscribe to our show wherever you're listening right now, and please leave us a review. It helps more people find the show. This episode was produced by the indispensable Anna Mazarakis, Moses Andem, and me. Our supervising producer is Magnus Henriksen, and we had editing help from Sage Bauman, Katie Boyce, Jeff Grocott, Mike Nitza, and Christine Vanden Beilard. Blake Maples does our sound engineering, and our original theme song was composed by Luis Guerra. I'm Tim O'Brien. We'll be back next week with another Crash Course.